Қайырлы күн, құрметті қатысушылар. Бүгін біз Climate Skills for Kazakhstan жобасының екінші аптасындамыз. Біріншіден, менің сұрағым, сіздер қалай жақсы естіп тұрсыздар ма, мені көріп тұрсыздар ма? Добрый день, уважаемые коллеги. Вторая неделя нашего проекта Climate Skills for Kazakhstan. Хотелось бы убедиться, что хорошо слышно и видно, чтобы дальше продолжить с лекцией.
Все good.
Окей, коллеги подсказывают, что все окей. Хотелось бы сделать небольшое интро перед тем, как мы перейдем к самой лекции с сегодняшним спикером. Сегодня, как я уже сказала, вторая неделя нашего проекта, и мы начинаем с лекции «Основ климатического права» с спикером Лоес Ван Дейк, которая является основателем климатического суда. Также она является юридическим консультантом в области вопросов прав человека, миграции и жертв насилия в Соединенных Штатах Америки. I'll be holding this in two languages, so let me do this in English as well. So today's lecture's topic is climate law fundamentals. This lecture today is going to be presented by Luz Van Dijk. She's the Climate Court founder, and she's also a legal consultant in the topics of human rights, victims of abuse in the United States, and the topics of migration. So some important notes before we switch to the lecture is that the Q&A session is going to be held after the lecture, and any questions you have, you can put them on the chat box on YouTube live streaming. For convenience, you can turn on the subtitles in English, just for your convenience, basically. And the QR code is going to be available just before the Q&A session, so make sure to scan it and make sure that you are attending the lecture today. Очень важные такие моменты, да, административные такие организационные аспекты, которые хотелось бы отметить, это то, что сессия Q&A будет доступна через чат-бокс YouTube. Вы можете направлять туда свои вопросы на русском и английском языке, и, соответственно, мы их адресуем спикеру, да. Для вашего удобства также можете включить субтитры на английском языке, и QR-код будет доступен прямо перед Q&A-сессией, в конце лекции. Вы можете отсканировать и убедиться, что сегодня вы посетили нашу лекцию. Также касаемо перевода, да, то есть мы осуществим перевод на русский и английский язык, и эти видео с субтитрами будут доступны уже после на YouTube. Поэтому сегодняшняя лекция будет полностью на английском. Luz Van Dijk is our speaker, and Luz, the floor is yours. Please share what you have here today on the climate law fundamentals topic.
Yeah, sure. Thank you so much. And also thank you to everyone who's tuning in today, because last week I actually had a look myself at the lecture, and even though I didn't really understand the language, I was really happy to see how many people are attending these lectures. And obviously I work in this space, so I'm really, really happy to see that students are keen to know more about this topic, because in the future we will really need your intelligence and ambition for climate. So if at any point throughout this lecture you have any questions, please just feel free to drop them in the chat box, and I will be able to access them. And I'll also leave some time at the end for a Q&A. So let's start with the first slide, please. So my name is Luz, and I'm from the Netherlands. As mentioned by Arai, I have a background in corporate law. I've worked with a lot of companies to address their contracts and commercial activities from a perspective that is more sustainable, human rights friendly. More recently, I founded a platform that's called Climate Court, and I cover a lot of climate litigation news from across the world. And at the same time, I'm in touch with a lot of lawyers that are on the ground bringing these climate litigation cases, and I'm actively consulting on these cases and how to put together a proper climate litigation lawsuit against the government or against the company, against whoever is harming the climate. So today I will focus on climate law fundamentals. It's a very broad topic, and it's as broad as we want to make it. And I'll try to focus on what climate law really is, but I'd like to take a very practical approach because, as you'll see throughout this more or less hour, knowing what the law is really one thing, but as with many other things in the climate space, you really need to see how it works in practice to see how efficient it can be. So international law really refers to the body of international agreements, treaties, principles, and customs that can govern actions of states and other smaller actors in relation to climate change. And it really covers a wide array of legal instruments designed to address global climate change by reducing greenhouse gas emissions, promoting sustainable development, and to encourage more international cooperation. So if you look at the concept of climate change, for example, you see that climate change is obviously a global issue, which transcends national borders. And this is why it is necessary that we have international cooperation and legal frameworks that address all of these countries together, because ecosystems, as well as economies, they're interconnected and they're global. So this means that the actions in one country, they can have really significant impacts on other countries as well. So this makes international cooperation really essential. But this is also what makes climate law such a difficult topic, and this is why it's so difficult to really work with it. All right, next slide, please. So I'm giving an overview of climate law here, the table of contents, and during this lecture I'll discuss the different foundations and sources of international climate law and how these have developed over the past couple of years. After that, we'll look at the role of international organizations within this framework, and I'll also discuss the legal principles that are existing in climate law, which is really the crux of the presentation. But as much as I can, as I mentioned, I'll try to place these in a practical context. And then finally, we'll look at enforcement mechanisms of climate law, including my favorite topic, of course, climate litigation. We'll address it really briefly. Okay, next slide. So before I can explain to you what climate law really is, we need to see what climate law isn't, because climate law and environmental law, they're really two different fields, and they're confused quite a lot with each other. But they're actually complementing each other. They're very much related and they're very similar, but they're different. Climate law is modeled after environmental law, but the two fields aren't the same. So as you can see here, environmental law is very broad. It covers all aspects of the environment, which includes air, water, land, or biodiversity. It can also cover issues such as pollution control, waste management, habitats, and even biodiversity, so endangered species. And its primary goal is to protect and to preserve the natural environment from different forms of degradation. So this can involve preventing pollution, for example, or mitigating damage from human activities, and ensuring the use of sustainable natural resources. So environmental law uses a wide range of regulations and directives to address that. Some of these are national, some of these are international, and these will set limits, pollution limits for industries. They protect wildlife, they might require environmental impact assessments, and so on. But climate law is much more focused than that. So it deals primarily with policies and measures to combat climate change. So it specifically targets the issue of greenhouse gas emissions and its impact on the global climate system. And the main goal of climate law is to stabilize those greenhouse gas concentrations in the atmosphere. So this might include reducing emissions, promoting renewable energy sources, fostering international cooperation, and a lot of other things, but these are the key aspects of it. So climate law itself really involves specific mechanisms designed to address greenhouse gas emissions. And that's what really sets it apart from environmental law. It's much more focused, much more specific on greenhouse gases, emissions, and how to reduce that. So during that explanation, it should be clear that there is also significant overlap, because environmental law can also address climate change through regulations. For example, if environmental laws are addressing deforestation, then anything to do with the deforestation will also affect the climate. So all of these legal frameworks are interconnected and they're working together towards the same end, but they're different, distinct fields of law. All right, next slide, please. So over the years, as you can see, it started in 1992 with the first real climate law. And after that, a series of really international climate agreements have been negotiated and adopted to combat climate change. So I'll be going over some of the key international agreements that shape international climate law. And there are some smaller agreements that I did not include in this presentation because it would become too detailed. So we're really doing an overview of what is out there. So the first one was 1992. This is the United Nations Framework Convention on Climate Change. And at the same time, this is not only a legal agreement, but this is now also an authority. So it's an international agreement, but it's also a body that's acting and working on climate. And this is the first international agreement that dealt with anything to do with climate change issues. It's really the foundational international treaty that initiated a global response to climate change. And it was adopted at the Earth Summit in Rio de Janeiro in Brazil. And the primary objective is to prevent dangerous human interference with the climate system. So it established the principles and the framework for subsequent agreements, including what we'll see next, the Kyoto Protocol and the Paris Agreement. Next slide, please. So in the same year as the UNFCCC that we just saw, we also had the Rio Declaration, which was adopted and produced at the same Earth Summit. And it consists of 27 principles that help countries in implementing sustainable development. So for example, you have the first principle that really sets the tone, I think, of what this document does. It says human beings are at the center of concerns for sustainable development. They're entitled to a healthy and productive life in harmony with nature. So it's really a critical document because it's the first time in international law that there was an emphasis that economic progress is linked. So economic progress is linked to environmental protection. Something that still to this day, I mean, it's like a good almost 30 years later, to this day, they still are struggling to actually implement this and to actually address this issue that economic development, climate change, environmental protection, that these are all linked and that they all continuously influence each other. All right, next slide, please. Then a couple of years later, we have the Kyoto Protocol, which was adopted in 1997, but it didn't come into force until 2005. So this was really a significant milestone in the global response to climate change because it extended the commitments of the UNFCCC that we saw earlier by asking of developed countries and transitioning economies to limit and decrease their greenhouse gas emissions based on specific targets. So this was the first time that we had targets that countries had to work towards. The UNFCCC before only asked countries to adopt certain policies or to report on their emissions, but they didn't have any targets at all. So the Kyoto Protocol really places a larger responsibility on developed countries due to their historical contribution to greenhouse gas emissions. And it also has something called Annex B, which is a part of this agreement. You can find it online and read through it. It's quite short, which really sets binding emission reduction targets for, at the time it was for 37 different countries. Now, at the moment, it's a lot more, but it started with 37 countries that had specific targets that they had to stick to in terms of their greenhouse gas emissions. And then the goal was to achieve a 5% reduction in emissions compared to the 1990 levels. So keep in mind, 5% compared to what actually they're trying to achieve now is really small. So the Kyoto Protocol was really groundbreaking at the time because of setting these reduction targets, but it was replaced in 2016 by the Paris Agreement, which is on the next slide, please. Yep. So the Paris Agreement, as I mentioned, came into force in 2016, but was adopted in 2015. And it's really, I think, the biggest achievement that we have internationally in terms of climate law. And it really represented the global effort to tackle climate change by limiting global warming to below, initially they said to below 2 degrees Celsius, above pre-industrial levels. But lately the focus has been more on the 1.5 degrees Celsius, which is also in the Paris Agreement. But it used to be a more aspirational goal, but now it's the target that we have. So the Paris Agreement reflected at the time that it was adopted the growing scientific consensus on the consequences of climate change, especially if we start exceeding these thresholds. So think about floods, intense heat waves, droughts, rising sea levels. They all started to realize that these were the consequences of climate change, and that's what the Paris Agreement is trying to address. So the Paris Agreement, it works on a 5-year cycle that tries to progressively set climate targets. So each country has to establish its own nationally determined contribution, which is called NDC for short, and they have to outline their emission reduction target and an adaptation plan for every 5 years. So every 5 years, all countries have to renew this. And this system, what they envisioned is to try and create a continuous improvement. So countries have to keep stepping up their game. Even if they're doing well, they have to do better in the next 5 years. And to support this, the Paris Agreement, it provides a framework for example, for financial assistance for countries that are struggling to actually implement climate adaptation or mitigation measures. Paris Agreement includes options for technology transfers, for example, climate tech, and capacity building. So they really focus on trying to help developing countries to implement their own climate action plans. And this emphasis on both ambition and support in the global community reflects the global understanding that tackling climate change requires really united effort from all countries involved. So that's on the Paris Agreement, and that's what we're working with currently. So these are really all the international agreements that are out there at the moment. It's not a lot. If you compare it to, for example, environmental law, there's dozens of international agreements tackling every specific issue of the environment. But for climate, we don't have that much yet. And what we have is also not without issues, as you'll see later on. All right, so next slide, please. Right, so we discussed the foundations of international climate law. Now we're moving into the sources. So a source of law can be really anything. In international climate law, it's predominantly shaped by 2 key sources. The first one we just discussed, so that's international treaties. These are referred to as hard law. So these are binding obligations that countries have to commit to, and once they commit, they have to stick to them. So this is what's called hard law. These are the international treaties. And then the second group is called the soft law instruments, which is a very broad group of agreements, for example, or declarations, guidelines, resolutions, and they all together form part of climate law. But what these soft law instruments have in common is that they they encourage only voluntary actions. They're not legally binding. Whereas international treaties and agreements, they are legally binding. They really obligate states to adhere to their provisions. So soft law instruments, they rely on more of a moral persuasion. So they ask states to stick to them because they have an ethical or moral obligation to do so. And soft law also lacks formal enforcement measures depending on compliance, or they're more sticking to peer pressure. So if one state sees another state not really sticking to what they should be sticking to, then there's the peer pressure of wanting to look good in the international community. So a couple of examples of soft law instruments include the United Nations Guiding Principles on Business and Human Rights. These provide a global standard for preventing and addressing the risk of adverse human rights impacts linked to corporate activity. So they're not legally binding, but they do influence corporate behavior and business policies across the world. And they've also been cited in litigation. Next, we have the second one is OECD guidelines for multinational enterprises. It's very similar again. These guidelines, they provide recommendations for responsible business conduct, but again, it's all voluntary, but they do address really good topics like environmental sustainability, climate change, human rights, all things like that. You can, if a company, for example, is in breach of the OECD guidelines, you can issue a complaint, and that's really harmful for their reputation. Then the third one on the list is declarations and resolutions. So, for example, international bodies like the United Nations General Assembly or the Conference of the Parties, which is the COP that's held every year, they can adopt declarations and resolutions to articulate shared goals in the international community and their commitments on climate change. And these do have, and it's not really inspirational, but they urge countries to stick to it, and it does help a lot. Then we have guidelines and frameworks, which includes, for example, those reports that the IPCC keeps publishing about the science behind climate change. So they produce scientific assessments or guidelines that really inform policy making and enhance understanding of climate issues. And then finally, we have voluntary agreements. And there's various initiatives across the world and partnerships between governments that contribute to climate action through these voluntary commitments, such as, for example, corporate sustainability pledges or countries agreeing to help each other out. But as I mentioned, despite the non-binding nature of all of these soft law instruments, they're really regularly cited in climate litigation, which is why they remain so important. So judges and courts, they can guide themselves by looking at soft law because it shows what the international consensus is on a very specific issue. Right. Next slide, please. Right, so we discussed the sources of law, the foundations of the law, but these are the international organizations that are actually using the law, or at least informing the law, shaping the law, anything to do with climate law. So they play a critical role in developing, implementing, but also enforcing climate law, international climate law. And they help to provide a platform for negotiation, scientific research, cooperation, any of these things. So the first one that I've included is what I just mentioned, is also an international body. It's the UNFCCC. And if you recall, one of the earlier slides said that this was an international agreement, but it's also an international organization. And this body really is tasked with addressing climate change and serves as a framework for global cooperation in climate action. And its primary roles include facilitating negotiations. So every year it organizes the Conference of the Parties, which is the COP I just mentioned. This year it's in Azerbaijan. Last year it was in the United Arab Emirates. So member states of the UN, they come here, they negotiate, and they adopt international agreements, such as the Kyoto Protocol, the Paris Agreement. And therefore, these conferences, they're really pivotal in setting global climate goals and commitments. Then their second task is to monitor implementation. So they review the progress of member states in meeting their climate commitments, and they collect, review national reports on greenhouse gas emissions, for example. Thirdly, they offer technical support, and they provide capacity building initiatives to help countries, especially developing countries, to implement climate policies and to meet their climate targets. And lastly, they use certain mechanisms to make sure that countries are acting transparently and provide accurate information about their climate action and the progress that they're making. Then the second international organization is the IPCC, which is a scientific body which was originally established by the United Nations Environment Programme. It provides really comprehensive assessments of the scientific basis of climate change, the impacts of climate change and future risks that are associated with climate change, as well as what we can do in terms of options for adaptation and mitigation. So its roles include conducting these assessments that I've just mentioned. They'll draft a report based on their assessments. Then secondly, they'll inform policy, which means that by providing their scientific evidence, they can help shape international climate negotiations and policy decisions. And the assessments conducted by the IPCC, they really underpin the targets and commitments made in international agreements like the Paris Agreement. And lastly, I think IPCC has a great function in raising awareness because a lot of their reports are distributed in the news as well. I understand a lot of their climate science, even though I'm not a climate scientist, by reading these reports, and they know how to break it down in a way that's understandable. So the third international organization is the United Nations Environment Programme, which is, as the name says, it's an environmental organization, not a climate organization, but they are the leading environmental authority globally that sets the environmental agenda, and they continuously are promoting sustainable development. And they play a very big role in supporting climate action. So they help countries to really develop, implement environmental and climate policy, and especially when it comes to climate change mitigation or adaptation. Second, they conduct a lot of research, they do analysis, and they produce, similar to the IPCC, they also produce reports and assessments, such as, to name an example, the Emissions Gap Report, which analyzes progress and really highlights the areas that need more attention in addressing global climate efforts. And lastly, they facilitate the United Nations Environment Programme, they facilitate environmental treaties and agreements that address different aspects of climate change and environmental protection. And then finally, it's a bit of a less well-known one, but the World Meteorological Organization, they are also a United Nations body, but they are responsible for promoting international cooperation in not just meteorology, but also climatology. So it's very scientific, but they provide a lot of climate data, they provide forecasts, they really have a good grasp on what is going on in the world, and they are able to visualize that. So they have early warning systems, for example, for certain climate disasters. And these are really essential for what is going to happen in terms of climate change and how we can respond to that. And again, this really helps us to put together policy to make sure that climate law is well informed and is up to date on what exactly the latest science is saying. Okay, next slide, please. All right, so this is really the fun bit, in my opinion, about international climate law. So I'll be discussing what the principles of climate law are, and I won't really go deep into the legal implications of each of these principles, but I hope that you can take away the general idea of what climate law is based on these principles, because it sets the tone for what exactly was intended with the Paris Agreement and its predecessors. And another comment that I have to make before starting is that these are really theoretical principles and they look great on paper, but things aren't working as well as we would like them to in practice yet, but hopefully someday. So anyway, the first principle is that of the common but differentiated responsibilities and respective capabilities, which is quite a mouthful, but the definition of this is that it's a principle of international climate law that basically it acknowledges the different capabilities and responsibilities of different countries in addressing climate change. So it recognizes that all countries share the responsibility of addressing global environmental issues or global climate issues, but not in equal measure. So every country has a different historical contribution to climate change, and every country has a different level of economic or technological development, and their response to climate change has to be based on all of these issues. So it has to be based on their historical contribution, but it also has to be based on their economic capabilities. If a country doesn't have that much financial resources, you cannot expect them to do a lot of things for climate or to address climate to a large extent. Similarly, if they have historically contributed a lot to climate change, for example, from the Netherlands didn't really do well. They contributed a lot. So it is expected that the Netherlands does more to address climate change at the moment. So this principle is really important because it promotes equity and fairness in international climate law. It also ensures that the burden of addressing global climate issues doesn't fall disproportionately on developing countries by acknowledging their lower historical contributions. And I think that this principle also fosters more global cooperation, and it really facilitates more inclusive and effective climate policies. So this was the first one. Next slide, please. So we have intergenerational equity. Sustainable development. Sustainable development refers to a mode of development that really it fulfills the needs of the present generation without compromising the ability of future generations to meet their own needs. So the concept integrates three core dimensions. You have economic growth, you have social inclusion, and you have environmental or climate protection, which ensures that progress in one area doesn't come at the expense of any of the others. So if you're engaging in any sort of climate action that is focused on just purely climate protection or climate adaptation or mitigation, whatever, it shouldn't come at the expense of social inclusion, for example. So to give a practical example, a really huge issue at the moment is, for example, women and how they're being affected by climate change, but also how women are affected by climate action because they're being excluded quite a lot of times or forgotten about, or especially if you look at small farmers, for example, they're often women in certain countries, and it's these women that are being affected disproportionately by climate change. So what sustainable development says is we have to make sure that however we address this issue, we have to make sure that it's fair and that it's equitable. So this principle is it's crucial for achieving long-term economic growth, social well-being, and sustainability. And it promotes a holistic approach to development that balances economic opportunities with social equity and environmental protection or stewardship. And by addressing the interconnectedness of these three dimensions, sustainable development really aims to create a more resilient and inclusive and environmentally sound society. So it ensures the well-being of current and future generations, and then all aspects of, or all layers of that generation. Okay, next slide, please. So now we come to intergenerational equity, which is the principle that fairness and justice have to exist among generations as well. So it's very similar to sustainable development principle, but it's only focused on the generational aspect of it. So it emphasizes that the current generations, our generation, for example, should manage natural resources and make certain policy decisions in a way that doesn't stop future generations from meeting their own needs and enjoying the quality of life that we are supposed to have right now. So you see this in action. For example, there was a climate law case recently in the EU. It wasn't successful, but it was about children and young children, especially, that are trying to get their government to take more climate action, because it's almost, what they argued is, it's almost discrimination by not taking any climate action, because they're discriminating against younger people, because it's the younger people that are having to suffer the consequences of not taking climate action. So again, this principle is really very much focused on long-term goals and long-term sustainability, and not just sustainability in the environmental sense of the word, but the social sense of the word as well, because we will continue to need people in order to protect climate and to protect the environment and to fight these battles for us. So this principle is really prioritizing the needs and the rights of future generations, and is encouraging to really responsibly use our natural resources and to adopt sustainable practices to protect them. So it ensures that the benefits of natural resources are really shared equitably across generations, even though some of these generations aren't here yet. And it's preventing what is called depletion of the environment, so that we run out of natural resources. It's really against that. Okay, next slide, please. Okay, we come to polluter-pays principle, which is an environmental policy concept. It comes from environmental law. Only the difference is that in environmental law, it's much easier to pinpoint who is a polluter, because, for example, you'll be looking at a company that is causing an oil spill. Let's say they're leaking oil into the ground, and it's very easy to say it's this company, this is the oil spill, so this is the effect that it will have on the people that are living there, or the environment, or whoever. With climate change, it's a lot more difficult to say who exactly is a polluter, because a company or a government, an individual, they may be emitting certain greenhouse gases, and then those gases are released into our atmosphere, and then some sort of chemical reaction happens, which then affects everyone. So it's really difficult to see exactly, at least legally speaking, who is polluting and how is that affecting an individual or a country or whoever. But the principle holds that whoever produces some sort of pollution, whether that's an environmental pollution or climate pollution, they should bear the costs that are associated with managing this pollution to prevent damage to the environment and damage to people. So this principle, it really focuses on the climate environmental cost of pollution to ensure that the price of goods and services, for example, reflects the environmental impact that they made when they were being created or when they were being sourced. So this principle has now been extended from environment to climate change as well. And it's really significant to promote accountability and financial responsibility for climate change or climate harms, whatever you want to call it. And by making a polluter really financially responsible for the cost of their pollution, it helps create a more economic incentive to reduce your emissions, because it's expensive. It gets more and more expensive to be a polluter. And companies and governments will be more and more encouraged to adopt a cleaner production method as a result. So the polluter pays principle supports the creation of a more sustainable and a more environmentally friendly business practice and policy in your country. Next slide, please. Okay, so the precautionary principle is an approach to climate management that really says that you should take preventive action in the face of uncertainty. So what that means is, if there's any potential risk to human health or the environment, or where scientific evidence is inconclusive when it comes to what exactly is going to happen to the climate, this principle, precautionary principle, is saying you should take precautionary measures anyway to prevent harm, even if the cause and effect relationship is unclear. So it's saying if it's likely, or even if it's not necessarily likely, but it's unsure, if some sort of climate harm will happen, countries are obliged to take steps anyway to prevent that climate harm from happening. So it's really an important principle because it promotes really proactive and preventative measures to protect our climate and to protect people from potential risks before it's too late. Because if countries would start acting when it's already happening, when that harm that wasn't really sure actually happens, it's already too late because the harm is happening. So you're emphasizing the precaution in the face of uncertainty, encouraging the adoption of more safe alternatives or safer practices, safer policies, and minimizing potential harms or minimizing the chance that harms might occur. And in my view, this principle is really important to address emerging or uncertain climate threats, such as, for example, new or unknown pollutants that we don't know that much about, or really devastating extreme weather that we're not sure if it could happen, but we should be protected against anyway, because if it does happen and you're not prepared, then the harm will be exponential. All right, next slide, please. So we've discussed all of the principles, and now we're looking at two legal principles that aren't necessarily limited to climate law, but they're really important in understanding international climate law from my view, because sovereignty and jurisdiction, they're two concepts that define the extent to which a state has authority and control over its own territory and actions, both within the country and outside of the borders. So these concepts are really fundamental to understanding why it's so difficult to use international climate law. And addressing climate change it really asks us to navigate a very complex relationship between respecting state sovereignty and at the same time ensuring that global cooperation is effective through these shared jurisdictional frameworks that we have, such as the Paris Agreement. So to explain these two legal principles, first off, you have sovereignty, which is the authority and independence that a country or state has to govern itself without anyone else influencing them. So in international law, this principle means that every state can control its own affairs, they can make their own laws, they can implement their own policies within their borders. And it's really necessary to respect sovereignty because it helps maintain national governance and autonomy and security, and it allows countries to create and enforce policies that are fitting to their unique set of needs and that help their own people. But with international climate agreements, such as the Paris Agreement, for example, these kind of documents, they will ask of states to adopt very specific measures and specific targets to reduce greenhouse gas emissions. And these commitments, that, such as those under the Paris Agreement, they can really conflict with a state's domestic policies or economic interests, for example. So in that sense, the Paris Agreement is challenging the traditional notion that we have of sovereignty, because effective climate action means that states voluntarily need to limit certain aspects of their sovereignty for the greater global good, even which I understand is quite difficult if you're a state, for example, that hasn't really contributed a lot to global emissions. So let's say you're very small, or you're still growing as a country, and then you have that international agreement that's telling you what to do, even though you didn't actually do anything wrong yet. It's the other countries that are now telling you what to do that were the ones that contributed a lot to the emissions. So this is why international climate law is so difficult, and it really involves participating. It asks countries to participate in setting common goals and to cooperate on certain strategies. And it's difficult sometimes to balance the need for global action with the respect for national sovereignty. So the second concept that I've added here on the slide is that of jurisdiction, which is different than sovereignty. And jurisdiction refers to the legal authority of a state to govern conduct of its inhabitants, of its companies, of anyone within that country, to enforce the laws, to resolve disputes that are happening within that country. So whereas sovereignty is more of an executive concept, jurisdiction is a legal concept. So in the context of international climate law, a jurisdictional issue can arise when climate impacts or regulatory measures, they extend beyond the national borders of that country. So for example, one country is causing climate change to such an extent that other countries are suffering. So what one country is doing, it's spreading across its border and it's affecting all of the countries around it. And due to the nature of climate change, this is what happens. This is really common, and it's a very well-known phenomenon. And this is, in legal terms, this is referred to as extraterritoriality, which means that something that happens within a territory is affecting the outside of that territory. So this is not just a legal concept, but it's also a climate concept, because climate change in one state affects the states around it. Similarly, laws implemented by one state, let's take Mexico as an example. And let's say Mexico implements certain laws to limit greenhouse gas emissions, then those laws affect the countries around Mexico as well. So the laws that they are deciding on affect what countries next to Mexico are doing or can do, which is extraterritoriality, and which is affecting the sovereignty of the states around it, because you're impacting their ability to create their own laws and their ability to govern their own countries, because you're encroaching on that territory. So in climate law, this means that if you are taking certain measures that have implications on other states, it's the concept of extraterritoriality comes in, and it's very difficult to enforce that. And it makes it really hard to make sure that there's cooperation, because especially with certain countries, they start to bring in political issues, and they don't want other countries to involve themselves in their laws or their policies or their decision making. So that's why sovereignty and jurisdiction in climate law are constantly, it's an issue, and constantly Paris Agreement is being challenged because of this. All right, next slide, please. So now that we've established the legal framework for international climate action, we can look at how do we ensure that countries follow through on their commitments. So because we have the commitments, but how do we know if countries are actually doing what they should be doing? So this is where implementation and enforcement of the law becomes really crucial, but it's often really challenging as well, because the primary responsibility of implementing international climate agreements is for national governments. So if a country signs up to an international agreement, the government of that country is responsible for following up on the obligations in that agreement. So this could involve making sure that the international obligations are included in your national laws. And to name an example, you have Pakistan. Recently, they included a group of laws to make sure that their international commitments are also reflected in their national climate laws. But any country might introduce new laws to curb emissions. So I think it's just an example. A lot of countries are doing this. And this is to make sure that they can meet the targets under the Paris Agreement, because these international documents, they're commitments. They're not national law. In order to actually make sure that everyone in the country is sticking to it, they need to put it into the national laws. And then on the international level, you have organizations like the UNFCCC that I mentioned already, and they monitor and they facilitate implementation, but it's very difficult for them to really enforce, because there's not much enforcement mechanisms in international climate law. And that's where things, in my view, get really interesting and very complex, because international climate law, it lacks a central enforcement authority. There's no world police force to hold a country to account if they're breaching international climate law. In theory, they're just able to do it. And in practice, they do. They are breaching. A lot of countries are breaching their obligations. And the issue that we don't have that international enforcement authority is because of the two concepts that I just discussed, sovereignty and jurisdiction. Because despite climate change being such a global issue, countries are very unwilling to give up their autonomy to address the problem themselves. So it's very much a political issue as much as it is a legal issue. And that's why the enforcement really starts to rely on political pressure and reputation more than anything else. And that's not really, for climate law, that's not really what you want to achieve, to be honest, because political pressure and reputation aren't very strong enforcement mechanisms. They're okay, they're nice, but you want something or some international body to say, ABC happened and that's why you breached the law. But there's nothing like that at the moment. And with political pressure, for example, or reputation, you're relying on a country's fear of suffering some sort of reputational damage. And you're relying on that being sufficient motivation for a country to comply with your international agreement. And falling behind on your climate commitments can mean criticism from other countries, but that's about it. But at the same time, international climate law, it's relatively new. It's not that new, actually, if you see that we had the first agreement in 1992, when no one was really talking about climate change that much back then. So it's not that new, but at the moment it's evolving really rapidly. And I hope that approaches to implementation, for example, and enforcement are also being developed constantly. So as the urgency of climate action intensifies, discussions have to be ongoing about how can we implement enforcement mechanisms that can really hold countries to account. And this would require us to explore maybe more innovative approaches for dispute settlement procedures or trade measures against non-compliant countries, just so that we can enforce the international agreements such as the Paris Agreement. But the key point here to remember is that while enforcement can be really challenging, the existing legal framework that we have provides a foundation, a strong foundation for international cooperation on climate change. which is already more than we had to begin with. And by holding countries to account for their commitments, we can jointly move closer to achieving a more sustainable future. Next slide, please. All right. So we're at my favorite topic now. Climate litigation is really interesting. It's very new. It's very innovative, in my view, and it's a growing alternative that is there because we're lacking these traditional enforcement mechanisms in international climate law, as I just mentioned. So climate litigation involves legal cases brought by individuals, communities, NGOs, or even countries against governments or corporations for their inaction or insufficient action on climate change. Climate litigation is really growing a lot around the world as well, with cases targeting national governments and corporations. And these lawsuits can really take various forms, including, for example, holding governments accountable, which is often done by citizens or NGOs that are suing governments for failing to meet emission reduction targets or by failing to adequately prepare for climate impacts. A second group that we have is suing corporations for emissions. So lawsuits are targeting companies more and more with for emitting greenhouse gases to such an extent that they're also contributing sometimes even more than countries. I think in the case against Shell in the Netherlands, they mentioned that Shell is emitting more than France, I think, at the moment. So it's exceeding levels that are just unprecedented. And this particularly involves companies in the fossil fuel industry, of course. Then a third group that's interesting is investor lawsuits. So it's shareholders of companies that are suing their own company, which means that they're suing the board of directors for failing to disclose climate risk or for failing to adequately manage a more sustainable path towards running their company. These haven't been successful yet. I would love to see them be successful, but not yet, unfortunately. And then the fourth and last group that I wanted to include is criminal cases against directors. So recently we had a case which is ongoing in France as well against the board of directors of Total, also a fossil fuel company, and also against its shareholders. So it's really a criminal complaint arguing that it's criminal behavior to not do anything about climate change and to knowing that climate change is so harmful for lives of people, to still continue running your fossil fuel company. So if this case is successful, which I'm really interested to see if it's successful, then these people on the board of directors and a couple of the shareholders, they actually risk prison time for causing climate change, which is really something that's super new. We haven't heard of that at all. So these are really the four key areas I think that are interesting to look into if you want to know more about it. But more broadly, we have some key landmark cases in climate litigation. So the first one that I included it's a case called Agenda. It's in the Netherlands, and this case, in this case, the judge said, the Dutch government has to take stronger action on emission reductions, and this is the first case internationally that said that, and every single climate litigation case afterwards has been modeled after this one. So this is really the foundational climate litigation case. And then I included a case called Klimasenioren, which is a European Union case where Switzerland was required to take stronger measures against climate change. So additional climate litigation cases have also been filed across the world, really. So there's a case in Russia, there's a case in South Korea, in Germany, Belgium, United States, there's multiple, France. And these are all cases that are demonstrating the potential of litigation as an alternative to proper enforcement of these international climate laws to influence national climate policies. And the way that these cases are contributing is that court decisions, they set new legal principles that can be applied in future cases, potentially shaping the interpretation of international climate agreements, for example. And secondly, litigation can help highlight areas where international climate law is weak or unclear and help to raise awareness to strengthen the legal framework that we have. So climate litigation is not really the perfect solution, but it's really a powerful tool in the fight against climate change, because it allows us to hold governments accountable, it allows us to hold corporations accountable, and it can help to accelerate the progress that we're making on climate action and to promote more ambitious climate policies at the moment. Right, next slide, please. Right, so I've covered everything that I wanted to cover. If you have any questions, please let me know. Feel free to connect with me as well. I included, I think at the start of the slides, I included a QR code. But yes, please, if there's anything you want to know. And I'm being sent the questions as well, so I'll read them out. And so the first question that I got was, could you please elaborate more on the procedure of complaints within the UNGPs on business and human rights? Is it possible for NGOs from Kazakhstan to file such a complaint? So with the UNGPs, there's no real process of filing a complaint. You can file a complaint with the OECD multinational guidelines, but let me double check if Kazakhstan is signed up to that. I think they should be. I'll have to double check to be sure, but basically you can file a complaint in any country that has accepted the OECD guidelines, and then the process would be that it can be an NGO. You don't have to involve a lawyer at all, which is really the good thing about the OECD guidelines, because you can draft a complaint. There's a couple of these principles. Then you can draft your complaint in a way that shows how a company, it's aimed at companies only, how that company is breaching those guidelines. So whether that is continuing to invest in fossil fuels or harming human rights or anything of that sort, you just have to show it, and then the OECD, they will consider it. And if they agree with you, they'll set up a sort of how to describe it best? It's a dialogue between whoever filed the complaint against the company and the company that is committing the violation. So it's really aimed at coming to a mutually agreeable solution, which is really helpful because with litigation or enforcement, it's very harsh. And I agree that it's needed in a lot of cases because companies are polluting to an extent it's insane, really. But with the OECD measurements, you can make sure that it's a more friendly conversation, I think, and you can at least help them understand you and help a company understand why certain action is needed. So I hope that this answers that question. And second, what are possible options for climate litigation on an international level for people from countries where the national legal framework doesn't have climate law? So I would recommend looking into existing national climate litigation. For example, if you look at the Dutch one, the Urgenda, because what they're saying is they're using the international climate law framework, such as the Paris Agreement, by saying this country signed up to the obligations of the Paris Agreement, and it doesn't matter that there's a lack of a national climate law, because the fact that there is no national climate law would be base to go after that country because they're not sticking to their obligations under the Paris Agreement. So in the Netherlands, under that case, they were saying, even though the Netherlands had some climate law at the time, they said it's not enough. under the Paris Agreement, you signed up for this, and this, and you're not doing that. So that's why we're coming after you as a government. That's why we're suing you. So it doesn't matter that there's no national legal framework. But I think the Dutch Urgenda case is really interesting to look into. The European one as well, because it's very much a similar argument. So another question is, could you please give real-life examples of some preventative climate regulations? I only know what regulations that deal with the consequences. I would say that it really depends on a country-by-country basis, but I would look into countries such as the Netherlands, France, and look into their climate laws, because these countries have a much higher obligation on what they need to include in their national climate laws. So it's countries that are historically contributing a lot to climate change. So countries that are polluting a lot, countries that have, for years and years run without check and without anyone stopping them from emitting a lot of greenhouse gases. Look into these laws that they have on a national level, because they're the ones that do have that obligation to help adapt and help mitigate and help prevent. I think the only two countries that you shouldn't bother looking into that have contributed a lot of greenhouse gas emissions are the United Kingdom and the United States, because their legal systems are really weak as well. So they're also really far behind on what they need to implement in their national legal systems. But yeah, I think Netherlands, look at France, look at the Scandinavian countries. What else? Switzerland obviously is behind, that's why they were being sued. Germany is I think, a decent one as well. But in my opinion, none of the countries across the world have what it takes at the moment in their climate laws. They're all looking at each other. They're all trying to figure out, what to include, what should we do. So even them having some sort of emissions regulations, for them it's already really an achievement, even though we're thinking, it's not far enough at all. Okay, fourth one is, please share more, or it can be a link about cases in Russia that you mentioned. Let me see. So the case in Russia, it's very similar to what I just mentioned. It's a case against the government for not going far enough in addressing climate change. I'm looking it up at the same time, 1 second, but they're saying, if I remember correctly, that Russia and the Russian government, by consistently not implementing any climate law or decent climate policy, they're just not meeting any of the obligations that they should be meeting. And in doing so, they're harming human rights, they're harming a lot of things that they shouldn't be harming. And they filed this complaint once before, but it was unsuccessful. 1 second. And I remember that the people who filed the complaint, they also suffer from a lot of political fallout from filing it, and they're really in danger of their life. I'll send the link, and then hopefully someone can share it in the chat. Okay, so next question. Does the lawsuit against subsoil users for not fully accomplishing their compensatory tree planting program fall under climate law or environmental? I would say it would fall under climate law. If a company or a government is committing to plant, I think that's, if I understand correctly, committing to plant a specific number of trees, and they're not really adhering to that, it would officially be climate law, but they're under no obligation to do so. That's why it's being used so much. It's very much greenwashing what these people are doing, because they'll say for every, I'm just giving an example, for every coffee that you buy from us, you get, we will plant 1 tree. No one knows if they're actually doing that. And even if they're doing that, it's not that impactful. And by the time that tree is actually helping to take CO2 out of the air, out of the atmosphere, decades have passed, and in those decades, the climate change will have worsened to such an extent that planting trees doesn't really work that well, in my opinion. There's a couple of exceptions with specific kind of trees or specific way of planting them, or how you're taking care of them, or how you're doing things. So it would officially, in theoretical terms, it would be climate law, because it has to do with emissions, but it's not really a legal issue, I think. It should be, but I don't think that it's going to be very successful under that. Yeah. All right. Those are all the questions that I received. If there's any other questions, then feel free to send them to me directly. And I'll wait for like a couple more seconds. But if there's nothing else, then I really want to thank everyone for joining today. And I hope that I was able to at least help the understanding of climate law, or even more, I hope that I inspired some people to be interested in climate law to the same extent that I am, because as you might have noticed, there's so many issues and there's so many shortcomings in climate law that we really need a lot of smart, intelligent people to think about these issues and to address them in their own countries, and to make sure that in an ideal world, I would like to see a world where every single country has climate law and climate litigation, and that people are working on these issues. So yeah, thank you very much for attending, and thank you to the organization as well for focusing on such an interesting topic.
Thank you so much, Luz, for your time. We really appreciate you joining our project, and I hope that our listeners really enjoyed the lecture too. Just another reminder that we have shared the link for attendance on our chat, just in case some people are having problem with the QR code. Other than that, we really appreciate your time. Luz, thank you so much. We hope to see you soon more, and thank you. Have a good one.